The gavel fell once, and the room drew a single breath. Life, without the possibility of parole. 2 counts. The words were measured, even. His grin vanished as if erased by an unseen hand. The trick of the mouth failed him. He stared ahead, neither brave nor remorseful, suddenly emptied of posture. Laura rose from the bench. "Your Honor, I need to speak," she said, her voice steady in the silence that followed. Across town, on a suburban porch months earlier, a doorbell camera had captured 27 seconds of ordinary night. A hooded figure crossing neatly swept concrete, a key on a light chain brushing metal, a quick sideways glance. The timestamp fixed itself at 10:12 p.m. Those seconds would come to define everything that followed. By the end of this account, the reader will understand why that glance, and the habit it revealed, turned a case into a sentence. Brookhaven preferred its edges clean. Trash cans stood at attention along the curb. Mailboxes held their small vows. Porches cast mild halos over hedges trimmed to geometric calm. Laura Kessler moved through that order with a nurse's metronome. 12 years in intensive care had taught her to keep time with machines and people alike. Her husband, Daniel, trusted codes, building codes, inspection protocols, the paperwork that kept roofs from sagging and beams from giving way. He believed in lines and margins because he had seen what happened when people ignored them. Their son, Aiden, learned the grammar of surfaces early. His room was immaculate, but no one entered. His answers in class were exact, but spared of warmth. Neighbors called him punctual. Teachers marked him precise. Order, however, is not goodness. It is only order. On a cold autumn night, a neighbor heard a thin cry and smelled something wrong in the air. She dialed emergency services with hands that would not keep still. Sirens began as distant threads and thickened into ropes of sound. First responders arrived in sequence. A patrol car, then Engine 12, then an ambulance crouching low with its light barred against the houses. The front door gave without protest. Heat pressed from the foyer like a guarded secret. They moved by practiced routine: primary search, utilities, salvage. A faint chemical note hung where it did not belong, and the backslider stood a fraction ajar. They found Laura conscious and confused, answering to her own name but not to time. Daniel was stabilized, then moved. No third person was located inside the house. Absence, they knew, is a form of information. There was no forced entry, and no witness who had seen a stranger approach. Investigators turned to the neighborhood eyes that never sleep. A doorbell camera across the street showed a slight figure cutting across the Kesslers' porch at 10:12 p.m. A drawstring hood up, a backpack low, a key on a chain grazing metal with a soft chime. The face never met the lens long enough to yield detail, but the gait did. Shoulders pitched forward, head slightly down, the right foot rolling inward. At one frame, the mouth lifted at a corner, a gesture as brief as static. It was enough to become a motif. Officers canvassed and found 2 more angles in a municipal pole camera up the block. Volunteers stitched the images and traced a path from a drainage easement to the Kesslers' fence and back toward Sycamore Lane. Detectives recognized the path as Aiden's usual shortcut to school. Perfectly ordinary, at 8 in the morning, out of place at night. A judge signed a warrant in the small hours. Location history for a phone. The shoes from the boy's room. The backpack. Any container that might once have held a volatile liquid. His laptop. His clothing. At dawn, officers located Aiden at a friend's garage 2 streets away. He opened the door with a smile that tried to look older than it was. "Am I under arrest?" he asked. "We have a warrant," a detective said. "We'll talk at the station." In interview room B, the rules were spoken aloud, one by one, and he acknowledged each in turn. His mother lay sedated in a hospital and could not be present. By policy, a youth lieutenant sat in, as a neutral witness to procedure. Aiden said he had been at the friend's garage for most of the evening. He said he lost track of time. He said a tread pattern could be a coincidence, and that cameras sometimes glitched. When the doorbell clip appeared on the wall monitor, he leaned back, then forward, and his breathing quickened by half a step. "Sometimes they do," the detective agreed. "But this frame doesn't." He smiled, a performance more than a feeling. Confessions rarely begin as confessions. They begin as rehearsals. He repeated the same 5 sentences in new order for 90 minutes. When he lifted the paper cup, his hand trembled on the way down, not on the way up. Asked again about counsel, he declined. "I have nothing to hide," he said. The detective placed a photograph on the table, the recovered backpack. Another followed. A key on a light chain. A third. The print of a shoe near the backyard slider. "People walk there all the time," Aiden said. "Not like this," the detective answered. "Right heel worn on the outside. The foot rolls inward when it lands." They spoke of heat and ignition sources, of timelines and distances. No one spoke about pain. The nouns remained clinical. "If I wanted to hurt them," he said. "There are easier ways." "They are your family," the lieutenant said. "Families fight," he answered. The monitor held on the 10-12 frame. He watched his own posture in gray scale. The corner of his mouth lifted again, as if the image tugged at a string. "What's funny?" the detective asked. "Nothing," he said. He admitted being nearby. He admitted a stupid idea of creeping onto the porch. He denied intent. He mentioned a small clink when the chain brushed metal and imitated the sound without realizing he had done it. Meanwhile, the evidence moved through hands in a line that was both physical and legal. Names were spoken over seals. Transfers were logged. Containers were opened and closed, and signed for. The defense would test each link later. For now, the chain held. By late afternoon, the file reached the prosecutor, Elaine Porter. The charges were as spare as they were heavy. First-degree arson. Felony murder linked to Daniel's declining condition. Attempted murder with respect to Laura. Porter wrote a private note in the margin. His mouth will convict him. Let him perform. Michael Reeve, the defense attorney, entered early, a patient craftsman of difficult cases. He sketched the outline he knew by heart. A developing brain. Hints of trauma. The human tendency to misread pressure as intent. He prepared a motion to suppress the interview on grounds that a true adult had not been available. Cameras caught Aiden as he was moved to juvenile detention. He did not lower his head. The corner of his mouth rose, half reflex, half posture, and the loop replayed on the evening news until it looked like a declaration. The courtroom felt like a machine built to separate adjectives from verbs. Bailiffs arranged the rows. The judge entered with deliberate economy, and the room adjusted its spine. Porter began with particulars that held even when left alone. The timestamp. The frames from the porch. The wear on a right shoe. The mapped path through neighborhood cameras. The admissions of proximity. The first responder's notes about an odor that did not belong. A volatile sample awaiting confirmatory analysis. Reeve answered with context. The age of the defendant, the science of suggestion, the risk of accepting an interview when a parent could not be present. The detective returned to the stand to explain where the doorbell file came from, how it was extracted, how its integrity was verified, how each seal on each envelope remained unbroken until it did not need to be. On cross, he conceded that cameras can lie in general, then narrowed back to the particular. This porch, this file, this night. Aiden watched himself on the screen and felt the old habit climb toward the mouth. He stopped it halfway. His right leg bounced once and froze. The defense promised an expert on juvenile suggestibility at a later hearing. Porter underlined a single word in her notes. Mask. The story would advance quickly from here toward opening statements, toward the slow scaffolding of evidence, toward a mother who would choose truth over habit. But the shape of the ending had already been sketched. A glance at 10-12. A chain that chimed. A smile that kept returning to the wrong moments. When the court ruled for transfer to adult jurisdiction, the room did not cheer or groan. It simply shifted to a new gear. The calendar reset, the caption changed, and both tables began to build the version of events they could sustain under weight. Opening statements arrived without theatrics. The prosecutor's voice was even, as if reading blueprints that had already been approved. She promised no more than 4 pillars. The timestamp at 10:12 p.m. The mapped path through neighborhood cameras. The laboratory confirmation that a volatile compound had been introduced, and the defendant's own admissions of presence and rehearsal of distance. Everything else, she said, was noise. The defense spoke in a lower register, asking for patience with a mind not yet finished. He invited the jury to think in gradients instead of binaries. to separate a frightened boy from a monster invented by headlines. He warned against mistaking posture for intent or immaturity for malice. He promised expert testimony on adolescent suggestibility, on the risks of interviewing a minor without a parent, and on the ways a developing brain misjudges consequences. The jurors listened the way people listen to a storm forecast. Some looked for certainty, others for margins of error. Evidence began where most modern stories begin, with data that remembered more faithfully than people did. Technicians described how the doorbell file had been copied and verified, how hash values matched at each step, how no one had altered the sequence of frames. The images themselves needed no narration. A slight figure crossed a porch with a backpack low on the spine. A small chain brushed metal. The head tilted once, and the corner of a mouth lifted as if out of habit. The clock fixed the moment at 10:12. The mapped path followed. Camera angles from 2 neighbors and 1 municipal pole stitched a corridor of movement through the subdivision. There were gaps, but the route held its shape. Sycamore Lane. A footwear examiner then approached the question of tread and wear. He was not theatrical. He explained how rubber forgets slowly, and how asymmetry announces itself over months. The right heel, he said, bore the signature of a foot that rolled inward. He compared test impressions with the lifted trace near the slider, and with the defendant's shoes, catalogued under seal. His conclusion was careful, consistent in a way that would be unlikely by chance. The laboratory chemist spoke in the language of peaks and retention times. A small sample taken from a fabric remnant near the origin of heat yielded a pattern that matched a common accelerant class. The report did not speculate about who carried it or why. It simply described what was present. A digital analyst closed the day with a timeline of a phone that had been asked to forget. He showed how location services had been toggled off and on, how system artifacts lingered, how motion data suggested a brisk walk between 10:08 and 10:16, how 2 deletions had occurred after midnight that did not fully remove their own shadows. He did not claim certainty in every minute. He claimed coherence. By the second week, the case took on the pace of habit. Witnesses introduced themselves, swore, told what they had seen or done, stepped down. The detective returned to knit the strands into a narrative that resisted coincidence. Aiden sat still and practiced the absence of expression. The mouth learned restraint, but at odd times, usually when the courtroom monitor went dark, its corner tugged upward, as if the muscle could not abide stillness. No one spoke about motive. The prosecutor did not need one, and the defense would not risk a story that might be disproved by a single text message. The trial moved forward on conduct and consequence. When the defense case began, the tone shifted almost imperceptibly. A child psychologist explained executive function as a set of tools that arrive at different times for different people. She described impulsivity, susceptibility to peer status, and the narrow field of vision that adolescence enforces. When a juror asked whether those features erased responsibility, the witness shook her head. They did not erase. They informed. A school counselor followed, a man with a gentle manner who knew how to talk about quiet students without making them sound noble. Aiden, he said, had always been controlled, punctual, precise, rarely in trouble, reluctant to admit error. He did not alarm teachers. He avoided them. The defense attorney tried to braid these threads into a portrait. A boy skilled at performance, limited at insight, built to withstand pressure until the wrong night at the wrong hour. He suggested that proximity did not equal purpose, that bravado could masquerade as distance, that a foolish, reckless gesture on a porch could look, in hindsight, like design. Cross-examination was not loud, it was patient. The psychologist acknowledged that impulsivity does not account for preparation, that toggling location services off and on suggests planning, not panic. The counselor conceded that Aiden's skill at avoiding adults might also be a skill at avoiding consequences. Each witness left intact but lighter, as if some weight had been carefully removed from their testimony. The motion to suppress the interview returned for decision in the middle of this exchange. The judge reviewed the record, the warnings given and acknowledged, the presence of a youth lieutenant as process witness, the absence of a parent, the defendant's repeated choice to continue. He admitted the interview with a cautionary instruction about age and comprehension. The defense registered its objection for the record and shifted ground. The jury finally heard the recording in full. It was not a confession in the cinematic sense. It was a long series of partial denials, stitched with acknowledgments of presence and stray remarks that did not know their own weight. "I was around," he said. "I wanted to see. It was stupid. I didn't mean for anything to happen." The detective's voice was level, never pressing for adjectives, always returning to verbs. In the middle of a sentence about the porch, Aiden mentioned the metallic clink of a key brushing rail. He made the sound with his mouth without seeming to notice. In the gallery, Laura pressed 2 fingers together, as if counting. When the recording ended, the room released its breath. The judge reminded the jurors that words could be taken for what they were, and not for what the parties wished them to be. Outside court, the city continued to behave as usual. School buses paused, delivered, and moved on. The leaf collection schedule was posted online and obeyed. Order held, because order is good at looking intact. In the hospital, before the trial began, Daniel's decline had been steady. By the time of testimony, it had become final. The indictment had already accounted for that possibility, and the caption updated with less ceremony than grief deserved. Laura returned to work on light duty for a time and then took leave again. People spoke to her softly as if loudness could break what was left. She perfected a nod that spared them. With her sister in the evenings, she practiced sentences in which truth and loyalty might coexist. The prosecutor called only a small number of experts, because each had done enough. The footwear examiner returned briefly to address a defense article about misattribution. He agreed with the caution and noted that in this case the conclusion had been described as consistent, not identical. The chemist responded to a learned treatise about common household sources. She conceded similarity and then explained the laboratory's protocol for distinguishing mixtures. The digital analyst asked about gaps in location tracking, embraced them. Phones have habits. People exploit them. Artifacts remain. The detective, last among the state's witnesses, did not raise his voice. He told the jury that cases like this one rarely turn on a single piece of proof. He told them that a motif can be a map. He did not say which motif he meant. He did not need to. When it came time for the defense to present character witnesses, few volunteered. A neighbor spoke about mowing schedules and quiet greetings. A classmate remembered Aiden as the one who always knew when a teacher would collect homework. None could speak to anger or gentleness or patience under strain. They could speak only to absence, of trouble, of closeness, of himself. The defense expert on interrogation, careful, precise, walked the jury through phenomena that make minors vulnerable. The authority of adults in small rooms, the tug to please, the way a closed door changes how time feels. He did not call the interview coercive. He called it potent. The prosecutor thanked him for the clarity and asked whether a person who believes himself clever is equally susceptible. Sometimes less, he said. Sometimes more. Throughout this, Laura sat with her sister on the end of the second row. She had not yet decided whether to speak at the end of the trial. She told herself that testimony was the work of others and that her duty was to remain. But neutrality is heavy in the hands. It shakes after a while. On a midweek morning, the defense suggested through a school counselor that Aiden had been pushed to excellence in a home that prized order over understanding. The phrase floated longer than it should have. Laura fixed her eyes on the grain of the rail in front of her and kept them there until the recess. In the hallway, she told her sister that kindness had been mistaken for permission too many times. The prosecutor did not ask her to speak. The prosecutor did not need to. People choose their own moments when the balance leans. As the defense case neared its end, the attorney tried to leave the jurors with a frame that lifted weight from intent. A reckless experiment by a boy who did not understand the edge he walked. A night staged to scare, not to destroy. A chain of events that outran its author. The narrative was careful, nearly elegant. It asked for mercy without using the word, but the record kept returning to 10:12. The gate across a porch where 2 people slept. The toggled phone. The clink that even he remembered. The half-smile that visited at the wrong times. The case did not need adjectives. It had time, place, and conduct. Laura slept poorly that week. She woke once, convinced she had left a kettle on, and stood in the kitchen staring at an unplugged cord. In the mirror, she practiced a single sentence, then another, then a fragment from a night shift years earlier. Consequences teach what indulgence refuses to teach. She did not yet know whether she would say it aloud. She only rehearsed the feeling of standing. By the time the defense rested, the courtroom felt thinner, as if conversation had scraped it smooth. The jurors had learned the room's rhythms, how the reporter paused between pages, how the judge lowered his eyes when he listened hardest, how the attorneys stacked their notes like small walls. Everything now leaned toward endings. Laura had told herself she would not speak. She had rehearsed the silence with the same discipline she used to chart medications. But silence is a form of choice, and she began to understand what it would cost. The prosecutor had not asked her to stand, and the defense had not warned against it. The decision belonged to her, and ownership carried its own gravity. On the morning that Miriam, her sister, delivered the impact statement she had prepared for months, the courtroom held itself steady. Miriam's words were careful and complete. She named Daniel's absence in the small ways it would accumulate. A loose hinge no longer fixed on a Saturday, a favorite mug left high on a shelf that no one reached for, a vacancy at the end of the table that the dog had learned not to sit beside. She did not describe suffering. She described subtraction. When she finished, she put the paper back into her purse and looked at Laura with a question that did not require sound. Laura rose. She did not bring notes. She did not look at either table. She looked at the jurors as if calling them to the same floor she stood upon. She said that she had believed for too long that love could absorb anything. She said that she had mistaken accommodation for care, and that she had confused the management of consequences with mercy. She described how small rules had been waived and then larger ones, how explanations had replaced accountability, how her son's skill at performing calm had made him seem harmless when he was merely contained. She said that goodness is not the same as the appearance of goodness. She said that order can hide a failure to learn. She said that a habit can become a refuge, and then a weapon, when no one insists that it end. She did not speak of the night. She spoke of years. She said that she had loved Aiden from the moment she knew he existed, and that love was the reason she had to be exact now. She turned slightly toward him and addressed him as if they were alone in a kitchen that had been quiet for weeks. She said his name once. She said that she had made excuses when she should have made boundaries, and that she had asked for patience when she should have asked for repair. She said that a home without consequences is a workshop for harm. When she finished, she did not weep. She sat down, and the silence that followed had weight. The judge watched the jurors, and the jurors watched the line of wood on the rail to avoid looking at one another. The defense attorney stood for a brief follow-up and asked if Laura believed her son capable of change. She said yes, because anyone is capable of change. But she added that the first step had to be naming what was true without disguises. The question ended there. Aiden had remained still throughout the speech, but stillness is not the same as calm. He had learned to wear quiet like a suit, and now it pinched. When the defense resumed with a short redirect of the psychologist, asking whether a mother's critique could distort a jury's sense of intent, something in him gave. It was not loud. It was the sound a rope makes when fibers separate. He muttered a sentence that no microphone fully caught. The second sentence came clearer and leaned toward the word unfair. An officer in the aisle placed his palm in the air without touching anything. The judge asked him to remain composed. The defense touched his sleeve and whispered. Aiden rose half an inch in his chair and sat back. He shook his head once, sharply, as if his neck expected to hit a wall that was not there. He said that people were building stories out of ordinary movements, that a gesture had become a verdict before any vote, that he could have saved everyone the time if he had known this was the outcome. He said he never meant for anything to happen. He said that you cannot convict a habit. The prosecutor remained seated and let the words arrange themselves without her help. The judge told the jury to disregard the portion they had not clearly heard, and to evaluate only what reached them cleanly. But Aiden had performed to the wrong audience. The room he had tried to control with neutrality saw him now unwilling to accept the structure that contained him. Closings were short by design. The prosecutor returned to the 4 pillars she had promised and resisted the gravity of adjectives. She told the jurors that motive was a story, and stories can be mistaken. But time, place, and conduct were not. She asked them to consider the toggled phone and the path that did not admit coincidence, the chemical signature that did not invent itself, the way a remembered clink reached the defendant's mouth before he understood it could matter. She asked them to measure their verdict in verbs. The defense offered the counterweight he had prepared from the first day. A boy with tools unfinished. A night that began as posture and spiraled past comprehension. A chain of custody that, while careful, was not a conscience. A confession that neared itself and then broke away. He told them that certainty is a high bar, and that the law prefers humility where doubt remains. He asked them to refuse the invitation to read design into ambiguity. He asked them to leave space for change. The judge charged the jury in an even voice that made the room sound as if it had been built for this sentence. He explained counts and elements. He spoke of the presumption that attends every defendant to the moment the state proves otherwise. He defined reasonable doubt without trying to reduce it to arithmetic. He told them to select a foreperson and to work as if words mattered because, in that room, they were the only tools that did. Deliberations were not dramatic. The jurors moved case files into one stack and then into several smaller stacks. They spoke in turns. They re-watched the porch frames without commentary. They asked to hear the interview again and listened to the parts they remembered and to the parts they had ignored. Someone drew a map on a legal pad. Someone else circled 10:12. As if the clock might change under ink, they returned sooner than some expected and later than others. Everyone on the benches looked the same until the door opened, and the faces were arranged into a decision that none of them would share until the papers reached the clerk. Guilty on all counts. The words were ordinary words. Their effect was not. Aiden closed his eyes the way people do when light becomes too much. The defense placed a hand near his arm and did not quite touch it. The prosecutor exhaled as if finally allowed to. Sentencing would follow in the afternoon. The interval between verdict and punishment is short in theory and long in mind. Aiden asked to be taken back rather than wait in a room nearby. He had not consented to the day and would not sit through its middle. When everyone returned, the judge looked older by an hour and steadier by 10 years. He acknowledged the absence that would never be repaired, the presence that would be relocated by law, and the city that would close its file without closing its memory. He said that some crimes are acts of impulse that burn bright and dim quickly, and some are constructions assembled piece by piece, even if their author tells himself he is only staging a performance. He said that the community expects sentences to teach what indulgence failed to teach, and that here the lesson had to be as permanent as the loss. He pronounced life without the possibility of parole on both principal counts, to run consecutively. He attached conditions and fees and credited time served as the law required. He spoke the words in the cadence the statute demanded, which is the cadence of a language that has been used too often to be ornate. Aiden's face answered with nothing at first. Then the familiar corner began to rise and stopped halfway, as if it had finally reached a wall that did not move. He looked ahead, not brave, not sorry, but no longer able to pretend that posture could outlast structure. Laura asked to speak, not to move the number but to mark the meaning. She said that home is a place that teaches, and that she had learned too late that teaching with excuses is not teaching at all. She said that she would visit if allowed, and that she would not lie about what had happened to protect a comfort that had harmed them all. She said that she loved her son, and that love now demanded accuracy. The judge thanked her, and told the room that the law does not repair families, but it can make a shape in which truth has room to stand. He said that the world of no consequences had ended in this case, and that it should end earlier and elsewhere when possible. The deputies moved in with their practiced calm. The click of a single clasp sounded louder than the crowd. Aiden stood and walked with the particular gait that had become a sentence in more ways than one. He did not look to the side screens where the porch frame had appeared a dozen times. He looked at the double doors and watched them reduce the room to a strip, and then to a line, and then to nothing. The people in the benches did not speak at once. They waited for the room to tell them it was allowed. Outside, the wind moved leaves along the curb, in long, narrow lines. The neighborhood resumed its routines because that is what neighborhoods do. Order returned to its familiar shape, and somewhere within it, a mother learned to live with a truth that changed nothing and changed everything. In time, the file would be cited in trainings and arguments for why juvenile masks can be harder to read than adult ones. In time, the doorbell clip would be used to illustrate how ordinary gestures acquire weight when placed beside conduct they foreshadowed. In time, the word rehabilitation would be spoken again with his name, because people are built for hope. And courts, even when they cannot grant it, do not forbid it in private hearts. But on that day, the math held 2 life sentences, a clock that would not cycle back, and a porch at 10:12, ordinary and permanent, like a hinge that never forgets which way it turns. The law prefers explanations that can be read aloud at a kitchen table. In the charge conference held off the record, hours before closing, the language had looked dense. On the page, elements arrayed themselves like algebra. In the courtroom, the judge translated them into sentences that could survive outside the building. For arson in the first degree, the jurors would decide whether a person knowingly caused a fire or explosion that endangered a human being inside a dwelling. Knowingly did not require prophecy. It required awareness that one's conduct would create that danger. And danger did not depend on the worst possible outcome. It rested on the risk that was created. For felony murder, the path was different and old. If a person caused a death in the course of committing a qualifying felony, intent to kill did not have to be proven. The law connected the acts like cars in a train. The engine pulled the rest in its wake. Attempted murder toward Laura presented its own arithmetic. The state had to prove a substantial step toward a killing, paired with purpose, or knowledge about the likely result. The phrase substantial step had been litigated for decades. Here, it would be carried by proximity, preparation, and the sequence of movements in those 27 seconds that many in the room could now sketch from memory. The judge told the jurors that reasonable doubt was not a speculative doubt or a wish. It was the kind of doubt that would cause a reasonable person to pause before acting in a matter of importance. He said that absolute certainty belonged to mathematics and theology. The law asked for something human but disciplined, a decision able to face mourning. He gave them instructions on how to consider statements by a defendant. Words that tend to admit presence or conduct may be weighed with care. Age is relevant to understanding, not to immunity. The jurors could examine whether the defendant appeared to have comprehended his rights, and whether he chose to continue freely after they were explained. He also explained that motive, while commonly discussed in stories, was not an element they had to find. People act for many reasons, for no reason, or for reasons they do not admit. If the elements were met, motive could not supply a missing piece, nor remove a present one. The chemist's testimony had sounded like a foreign language to some. After court, one juror drew peaks on a pad to make sense of it. The lab's work, in plainer terms, compared the pattern of a volatile residue to known standards, much as a fingerprint is compared to a file. Instruments heat a sample and carry the vapor along a column. Compounds separate based on how they interact with the material inside. As each emerges, a detector registers its arrival, and the pattern is recorded. 2 runs, one on the sample, one on a standard, create graphs that can be compared. Similarity is not identity, but similarity within expected tolerances becomes a kind of signature. The chemist had not claimed the impossible. She told the jury what the lab could say and what it could not. It could identify a class of products consistent with the residue. It could say that the pattern matched what would be expected if such a product had been present. It could not say who carried it, or why, or whether the person had understood the risk they were creating at the moment they acted. The machine could not read minds. It could only read peaks. The footwear examiner's caution worked in a similar way. He resisted the theatrical temptation to speak of certainty. He showed wear at the right heel and explained how pronation leaves its small history in rubber. He noted features of the tread that appeared in the impression lifted near the slider and in the defendant's shoes. He called the relationship consistent, unlikely by chance, and stopped there. The word consistent is modest by design. It sits on a shelf that the law trusts. Before trial, the parties had spent weeks in the slower machinery of discovery. The state disclosed police reports, lab reports, video files, transcripts of interviews, and certificates attesting to the preservation of electronic evidence. The defense asked for raw data, the unprocessed doorbell stream, the firmware version, the extraction logs, the full phone images from which location artifacts had been derived. They argued over redactions. The judge instructed them to remove what the law required, and nothing more. Motions in limine attempted to clear the aisle before the jury walked down it. The state asked to exclude references to rumors that had sprouted in the first week, when people with cameras and microphones had needed to fill air. The defense asked to forbid a phrase that had crept into headlines, the one that made a posture into an epithet. The judge agreed. The courtroom would speak in verbs, not captions. A separate motion challenged the interview. The defense argued that a mother in a hospital is no mother at all, that the youth lieutenant's presence was a process bandage, not a guardian, that a 17-year-old's nod could not carry the same weight as an adult's signature. The court looked at the record. The rights read aloud and explained. The immediate clarifications offered. The defendant's own words about stopping if he wished. An instruction would remind the jurors that age matters, not as an escape, but as a lens. The interview would come in. At sentencing, the judge spoke briefly about appeal as a right, rather than a rumor. The notice must be filed within a period that the statute names in days, not in seasons. Grounds must be particular. The admission of a statement, the sufficiency of the evidence, the calculation of a term, an instruction that misdescribed an element. Courts above do not retell the story. They examine whether the rules of telling were followed. He also described what would happen next in ways that people outside the system almost never hear. The defendant would be transported to an intake facility where a battery of assessments would be performed. Medical, psychological, educational, security. The sentence would travel with him as a document and as a number. The number would govern where bodies could go and who could touch which doors. Victim services staff met with Laura after court in a quiet office with 2 chairs and a clock that did not tick. They explained notification systems for parole hearings that would never come, because life without parole is a blunt instrument. They offered counseling, groups, and a list of organizations that help people find language for what has no adequate language. She accepted a card and folded it in half before she placed it in her wallet. On a different day, in a room with the friendly name of conference, the prosecutor debriefed her team. They noted what had worked and what had merely passed. The OSINT stitching had been invaluable but would require a written protocol next time to make the path from neighborhood cameras to court more formal. The footwear testimony had been just enough, not too much. The chemist's restraint had probably carried more weight than a louder claim would have. The detective's habit of returning to the particular had kept the case from drifting into parable. The defense team gathered as well and performed their own audit. The psychologist's testimony had been clear and careful. The jury had treated it with respect. The interrogation expert had landed 2 important points: that children in closed rooms experience time differently, and that confidence does not immunize against suggestion. But the problem had not been expert against expert. It had been a record that kept resolving into the same picture. Back in Brookhaven, autumn edged toward winter. Aiden's school released a note about counseling resources without naming him, because names can split communities. The principal stood in front of faculty with a script that had been provided by the district's lawyers. He followed it, then folded it in half, and spoke for a few minutes in his own voice about the difference between order and care. Laura returned to routines that were not routines anymore. She woke before her alarm as if her body distrusted rest. She cleaned the coffee maker, though she no longer drank coffee. In the afternoons, she met with a counselor who asked questions that did not direct her answers. On the 3rd session, she brought a notebook and wrote 2 columns labeled Boundaries and Excuses. The pages did not balance. Miriam joined her for dinners that were mostly quiet. They shared newspaper clippings only when the sentences were about procedure. They avoided adjectives as if the house were allergic to them. In time, they learned to speak about Daniel without making the room tilt. A legal aid clinic invited the prosecutor to speak to interns about the case. She did not bring slides. She told them that what mattered most had been the discipline of small claims. To say enough and stop. To resist the gravity of motives when the elements already fit. To prefer verbs. She told them that a jury is a temporary community and that communities respond to clarity and humility more than to theatrics. The detective lectured at the academy about doorbell systems, not as a technology, but as a chain of custody problem. He explained the difference between grabbing a clip from an app and performing a forensically sound extraction. He told the recruits to write down firmware versions, to document motion triggers, to avoid converting file formats casually, to preserve hashes at every step. He ended with a reminder that a frame is not a person, and a person is not a frame. The room was quiet when he finished, which is a good sign in such rooms. An appellate defender, unconnected to the case but interested in its contours, recorded a podcast episode about juvenile statements and the weight of habit in evidence. She described the tension between a minor's diminished capacity and the community's demand for safety. She questioned whether a youth lieutenant's presence should ever stand in for a parent. She wondered aloud whether the law's love of elements sometimes obscures the complexity of human intention. She did not say the conviction would be reversed. She expected it would not. She asked for better guardrails nonetheless. In letters that Aiden wrote but did not send, he described a calendar that no longer resembled months. Intake had given him numbers to memorize, a unit, a schedule, a tier of privileges that began at 0 and climbed slowly. He wrote about the quiet noise of doors, the choreography of movement ordered by other people's hands, the way a day without choices first irritates and then dulls. He did not address his mother by name. He wrote instead to the ghost of a porch at 10:12, as if the scene were a person he could apologize to. He said he had believed that performance could redirect reality, that a smirk could stand in for control, that a chain's small song was nothing. He did not ask for forgiveness in the letters. He asked for a way to name what he had done without using words other people had provided. The letters stayed in a drawer that a case manager would one day open during a routine check to ensure there was nothing dangerous inside. The pages smelled like the soap the facility purchased in bulk. On one, the case manager paused over a single line that read, "I did not think consequences were part of my house." The community remembered the trial cleanly for a while, and then fuzzily. People recalled the timestamp, the gate, the chain. They forgot the chemist's surname and the number of pages in the lab report. They misremembered who had said a particular sentence, until the transcript was consulted and showed that no one had. On a spring morning, 6 months after sentencing, a restorative justice group asked Laura whether she would speak to parents about boundaries that do not look like love until later. She agreed. Contingent on format. She would not dramatize. She would read from her notebook. She would say that kindness without expectations is a beautiful road that leads nowhere. At the event, she read 3 pages. She did not mention Aiden by name. She described how permission can dress as patience, how excuses can dress as care, how a home can tolerate small violations because they are easier to clean than conflict. A handful of parents cried without making sound. Others took notes, as if rules could be written quickly and posted like recipes. Afterward, one father stood alone by a bulletin board covered in flyers for things that happen in ordinary towns: pancake breakfasts, recycling days, a fun run whose logo made running look fun. He folded the group's handout into a tight rectangle and placed it in his pocket with the unshakable feeling that he had just learned the right word for something he had seen and could not name. When the appeal was filed, the brief was professional and contained nothing the public would find exciting. It challenged the admission of the interview on specific grounds, argued that the footwear testimony should have been further limited, and suggested that the jury instruction on attempt had not fully conveyed the requirement of purpose. The state's response was brief in reply. The warnings were clear. The testimony was careful. The instruction tracked the pattern. The court above would write its opinion in due course. None of that changed daily life along Sycamore Lane. Mailboxes still kept their small vows. Trash cans aligned with the curb. Order returned because order is resilient, and because communities must do something with their hands while their minds consider what cannot be fixed. In a quiet moment that might have been called peace if it lasted longer, Laura sat at the kitchen table and reopened her notebook. Under boundaries, she wrote, "Say no, quickly, and explain slowly." Under excuses, she wrote, "Don't confuse exhaustion with grace." She closed the book and stood to make dinner for 2. The dog settled by the empty chair as if certain that his job was to fill space. The story of that house did not end. It redistributed itself. It moved into classrooms where counselors taught about adolescents who appear calm because they have learned to be unreadable. It moved into police lectures about how to touch digital evidence without bruising it. It moved into judicial memory as an example of a case where the least dramatic explanation was the most accurate. That conduct, measured in minutes, can outweigh a lifetime of surfaces. If anyone asked the prosecutor what she remembered most, she said it was not the clip at 10:12 or the phrase that played on television. It was a single sentence from a mother who chose truth over disguise. A home without consequences is a workshop for harm. The line fit in the mouth easily and would travel farther than the case citation ever would. If anyone asked the defense attorney what stayed with him, he said it was the weight of a young person's belief that performance could replace responsibility. He did not say this to criticize. He said it to warn. He had sat beside too many bright boys who had mistaken a mask for armor. And if anyone asked Laura what she wished for, she answered carefully. She wished for no more training cases made from families. She wished for earlier words in other houses. She wished that her own love had spoken boundaries out loud when they were small enough to be carried without both hands. She did not wish for a different son. She wished for a different season within the same life. On an ordinary evening, she stepped onto the porch as the streetlights came on. The concrete held the day's faint warmth. Somewhere, a chain brushed metal with a sound no one else would notice. She stood a long time without moving, then went inside and locked the door, not out of fear but out of habit that finally meant what it should have meant all along. An hour after sentencing, the clerk stamped a page that would begin a separate life for the case. The notice of appeal did not retell the story. It preserved questions in a form the next court would recognize. Dates were calculated in days, not in grief years. The defense marked 3 grounds: admission of the interview, scope of the footwear testimony, precision of the attempt instruction. The paper did not argue outrage. It argued procedure in full sentences. A few towns away, intake processed a new person whose name had become a number. The sequence started with identification and moved through health, mental status, education, and security. The assessment was routine by design. Routine keeps systems human. A nurse asked questions and did not flinch at answers. A counselor measured risk with instruments the public does not see and wrote recommendations for a unit and a program track. The term life without parole did not require a new rubric. It attached to the file like a heavy clip. Orientation lasted 3 days. Aiden learned the geography of a place that decides everything before he wakes. He learned the schedule by sound. Doors, shoes, carts, voices, clipped short so they fit the corridor. He learned what could be sent through the mail and what must be purchased inside. He learned how a visit is converted into minutes that pass whether people speak or sit. He learned that programs exist even where time does not end. Anger management that does not excuse. Literacy for those who missed it the first time. A class on choices that begins with facts instead of promises. The first letter he wrote to his mother was functional. It asked what could be sent and what should not. It listed the days he could receive calls and the way money moves through accounts in amounts that look small until multiplied by weeks. He did not apologize. He did not defend. He described a cell as if inventorying a closet. He ended with the sentence, "I am learning to count without clocks." Laura left the letter on her table for a day as if it were a photograph that might change under sunlight. She answered with practical information and added a single line. "I will visit, but I will not disguise the truth to make the room easier." She mailed the envelope and kept the receipt. Not because she distrusted the mail, but because a record can steady a hand. The appellate record assembled itself with a speed that looked slow from the outside and fast from within. Transcripts were prepared and corrected. Exhibits indexed. Digital files copied in formats the court system would accept. A table of contents grew like a map. The defense brief arrived with citations that brought other rooms into this one. Cases about minors and warnings, about patterns of tread, about the line between risk and purpose. The state answered, shorter and spare. A reply followed, polite, pointed, disciplined. At the high school, the counselor who had testified held a voluntary session for parents who wanted to talk about boundaries. He used no names. He described a type of quiet student who confuses adults by presenting competence without connection. He explained how performance can mask confusion, how compliance can hide an absence of understanding, how praise without tasks can make a person fluent at surfaces. He recommended small, repeatable practices. Ask for explanations, not slogans. Praise, repair, not charm. Teach that consequences are not anger, they are structure. The room wrote down sentences in their own words, so they could become their own guidance, instead of his. Police training incorporated a short segment on residential cameras into its evidence block. The detective stood beside a projector, but most of the learning happened with clipboards. The recruits practiced writing down firmware versions, battery status, storage capacity, and the exact steps taken to preserve files. They were taught to record hash values at extraction and to avoid converting formats without a clear record of each change. They practiced describing a gate without overstating what the camera could know. At the end, each recruit had to write a paragraph that would make sense to a judge who did not live with gadgets. The detective underlined phrases that would survive cross-examination and crossed out those that would not. The prosecutor attended a community forum where she was asked whether motive would have mattered. She answered the way she had answered in court. The law requires elements, not stories. Motives can be true and irrelevant at the same time. She added that courts and families talk differently about harm, and that both languages matter. A parent in the back raised a hand and asked how to teach consequence without breaking a child. She said, slowly, "That consequence is not a hammer. It is a door frame. It holds shape. People do the walking." In the second month, Laura visited. The logistics were not hard. They were simply unsentimental. She stood where she was told to stand, surrendered what she had been told to surrender, and waited where she was told to wait. The room was made of things that last. Metal, thick plastic, a paint called institutional beige by people who sell it. When he entered, Aiden looked as if he had rehearsed a version of the meeting in which he would surprise her by being more himself than before. That version collapsed when he saw that she had not brought a story old enough to hide inside. She asked him questions and did not correct his answers. She did not use the word forgiveness, and he did not use the word unfair. She told him that she would read anything he sent and answer what asked for an answer. He told her that he had enrolled in a class that began not with the word anger, but with the word conduct. He said the instructor refused to accept synonyms when a verb would do. She noticed that he had remembered one of the judge's phrases without saying that he had. On the way home, Laura stopped at a grocery and bought the same items she always bought. Not because they were comforting, but because meals do not assemble themselves. At home, she opened her notebook to the page where she had written, "Boundaries and excuses." Under boundaries, she added, "Begin earlier than seems necessary." Under excuses, she added, "Do not call relief compassion." The appellate panel scheduled argument for spring. The lawyers prepared as they always do, imagining questions and resisting the urge to answer the questions they wish would be asked. The defense would press the limits of juvenile comprehension and the sufficiency of the instruction on attempt. The state would return to verbs and elements and the record that had been made. The panel would listen hard and write later. Outcomes would be measured in paragraphs, not in epiphanies. In the third month after sentencing, a restorative justice group sent Laura a brochure. It explained a voluntary process that allows victims to write letters that are delivered through a mediator. The letters are not instruments of negotiation. They are documents that give shape to experience. If both sides agree, a meeting may occur in a controlled setting, with preparation lasting longer than the meeting itself. Laura considered the offer and did not answer for 2 weeks. She had no appetite for scenes that pretend to transform anyone in an afternoon, but she believed in writing as a form of work, and in questions that hold a person to the chair until they are asked aloud. She told the facilitator that she would start with a letter, and that she wanted the letter to be useful even if it never left the file. She wrote in the evenings, stopping only when the lines began to repeat themselves. She did not negotiate past events with words like, "if only." She made 3 sections. The first described facts in small units of time and space: a porch, a minute, a chain, a glance. The second named the cost without adjectives. The third told him what she would do with her days. She would work. She would not sanitize. She would visit. She would not lie on his behalf. She would teach what she had not taught early enough. The facilitator reviewed the letter for clarity and safety, which in this context meant accuracy and the absence of blame language that pretends to be instruction. Aiden read the letter in a small office with 2 chairs of different ages. He asked for a day before he said anything. When he spoke, he did not dispute. He asked how to answer a letter that did not ask a question. The facilitator told him that an answer without a question is called an account. He wrote an account that sounded like a report from a place where the days had numbers but few names. He described what he had learned about himself that was not flattering and not cruel. He wrote a single sentence that was new for him. I mistook practiced calm for self-control. He did not ask for a reply. He thanked her for the letter and returned it to the folder where documents go to become permanent. In the neighborhood, roofers replaced shingles after a windstorm. A resident petitioned for a stop sign at the corner where a near miss had occurred. Children practiced for a spring concert that would sound like every spring concert since humans invented middle school instruments. The ordinary work of a town continued, and the case, once loud, became one more reference point people used without thinking when they wanted to warn each other gently. On a Saturday, Miriam and Laura cleared the garage. They said out loud what each item was and what it would be now. Keep, donate, recycle, discard. Saying the verbs made the choices feel less like betrayal and more like maintenance. At the end, there was space on the floor that no one had seen in years. Laura swept the new square of concrete and stood in it for a moment longer than she needed to. Some months later, the appellate court issued its opinion. It was careful and unsurprising. The panel affirmed. The interview was admissible under the jurisdiction standards with the cautionary instruction the trial court had given. The footwear testimony was properly limited to consistency, and the jury instruction on attempt tracked the pattern and did not misstate the law. The opinion cited cases that law students memorize and included a paragraph that acknowledged the gravity of life sentences for the young, while noting that legislatures, not courts, draw the lines for punishment. The decision did not cause an argument in town. It caused a page to be filed in a folder. The defense notified Aiden, who read the summary, breathed out once, and asked for paper. He wrote to his mother that he had expected this, and that the room did not change when the door was locked more firmly. He wrote that he had been reading a manual about maintenance because manuals are honest about what fails, and he wanted to learn a language in which repair is something you do, not something you describe. The counselor at the facility invited him to join a literacy program as a tutor. The role did not come with rank or special rules. It came with work. He sat beside a man who read the word consequence as if seeing it for the first time and tried to explain it without using the words that had wrecked his own house. He learned that teaching requires structure and patience, and the humility to start again when a sentence will not move. In her own house, Laura adjusted the doorbell camera's settings without ceremony. She replaced the device with a newer model that saved files in a format the detective would approve of. She did not keep alerts on her phone. She chose a schedule that recorded when she told it to record and stopped when she told it to stop. The tool had a job again. It was no longer a symbol. One evening, she set water to boil at 10:10 and poured tea at 10:12 without looking at the clock. The time announced itself on the stove in small blue numbers. Nothing else happened, which was the point. She took her cup to the porch, sat for 10 minutes, and went back inside to call her sister. If anyone had asked her then whether the story was over, she would have said that stories do not end. They settle. What ended was the season in which silence dressed as care. What began was a form of speech that could live anywhere. In kitchens, in courtrooms, in letters, in rooms with doors that do not open from the inside. Years later, an advocate asked her for a single sentence she wished someone had said to her when Aiden was small. She answered without pausing. Teach the rule before you apologize for the rule, and keep teaching it when you are tired. The advocate wrote it on a card and read it aloud at the close of every workshop until it sounded like something that had always been known. The case remained in the system as numbers do, searchable and still. But for the people who had carried it, the weight changed form. The detective retired 2 winters after the opinion and kept a small notebook in which he wrote phrases that kept cases honest. The prosecutor moved to a unit that trained younger attorneys to stop when enough had been said. The defense lawyer taught a seminar titled Responsibility Without Spectacle. Each carried something forward that did not sound like victory. It sounded like adjustment. On a morning that looked like every other, Laura left for work a few minutes early. She locked the door and tested the handle, then looked down the street where children waited with backpacks that were heavy for reasons that had nothing to do with school. She wished for them what she wished for everyone now. Early boundaries spoken kindly and repeated until they were strong enough to stand when no one was watching. The file had become a cabinet number and a set of deadlines met, but the people who lived inside it did not move according to calendars. Time stretched and folded for each of them in different places. The story that the town had once recited in headlines now lived in shorter phrases. The porch, the chain, 1012. Children repeated them as warnings without knowing where the words had come from. A juror, months after the verdict, found the clerk's envelope in a drawer and reread the standard letter that thanked them for service. She had underlined one sentence during deliberations. Consider the evidence without fear, favor, or sympathy. At the time, it had sounded cold. Now it sounded like a way to be kind, to give the case the dignity of precision, and to allow the rest of the kindness to happen elsewhere. She put the paper back and finally slept a full night. The judge taught a continuing education class for younger colleagues. He did not show them the porch frames or the interview transcript. He showed them his notes from the charge conference, small arrows where he chose a word like purpose instead of desire, an asterisk where he explained that knowingly does not mean predicting outcomes, it means understanding the risk you create. He told them that a sentencing hearing is not a sermon. It is a map drawn to scale so that people can find their way back to the law the next morning. The prosecutor visited a classroom where the teacher had asked her to talk about civic work. The students were not interested in punishment as spectacle. They were interested in what to do when someone they love makes harm. She told them what she had learned after this case, and others like it. You cannot bargain with reality by narrating it in a different tense. You can only decide what to do next, in the correct tense. A boy in the back wrote this down as if it were a formula. The defense lawyer returned to the jail where he sometimes met clients who did not yet understand that stories have to survive cross-examination. He kept a list in his pocket to read before each meeting. Do not confuse posture with courage. Do not confuse regret with repair. Do not confuse youth with innocence. He read the list like a quiet vow and put it away before the door opened. In a letter he did send, Aiden told his mother that tutoring had taught him the difference between understanding and repeating. He wrote that he had believed for years he understood rules because he could recite them. He now recognized that understanding is the ability to operate when no one is watching. He did not ask for a reply. He acknowledged instead that replies are work and that he had assigned her too much of it for too long. Laura's life did not acquire new ceremonies. It shed old ones that had never helped. She stopped apologizing for boundaries. She learned to end conversations that kept trying to rename the past. She kept the doorbell camera, not as a relic, but as a tool. When its app suggested a memory compilation, she turned the function off and smiled at the accuracy of the button's label. Manage. On the anniversary that no one marked publicly, Miriam came over with notebooks and a cake that neither of them wanted, but both of them would slice. They sat with coffee and named out loud what had improved. Sleep, sentences, the ability to stand in lines without scanning for exits. They said one thing they had learned, and one thing they still did not know. They laughed once at nothing at all, which turned out to be something worth noting. At the prison, the case manager closed Aiden's quarterly review with the sentence, "Stable in program." It looked like a weather report, because bureaucracy favors clear skies. He had not earned special privilege or trouble. He had earned a routine. In a place that turns on routine, that is not small. An intern at the appellate defender's office summarized the opinion for a training binder and wrote a short note in the margin that no one but the next intern would read. If you want to change outcomes, change statutes. She slipped the binder onto a shelf, where it would wait for the next case that looked like this one from far away, and turned out to be its own machine from up close. The detective, officially retired, walked neighborhoods out of habit. He watched how people installed new cameras at strange angles, pointing at sky or hedges, and he wanted to knock and offer small corrections. He did not. He went home and wrote a one-page guide he planned to hand to the next academy class. Document the device. Maintain the chain. Describe actions, not intentions. Speak in the present tense when you can, because the past is already crowded. One evening, near the end of winter, Laura drafted a short letter to a group that trained school counselors. She offered to come once and read 3 pages from her notebook without taking questions. She wrote that she was not a cautionary tale. She was a witness to a vocabulary, boundary, consequence, repair. The coordinator wrote back the same day and asked for a date. She read the pages the following month in a multi-purpose room with poor acoustics and good chairs. She did not mention names. She described the daily labor of rules, said gently, and repeated consistently until they belong to the house more than to the person who says them. At the end, the counselors did not clap. They packed their bags quietly, which is how people behave when they have work to do. For a time, the town could go weeks without anyone saying the number, but the number did not dissolve. It remained printed at the bottom of a docket, stamped on envelopes, spoken once a year in a review that confirmed nothing had changed. That was the point. Not all clocks should move. The last letter in this story is small enough to hide in a pocket. Aiden wrote it after a class where the instructor asked for a sentence each man wished someone had said to him earlier. He wrote, "Posture is not character, and silence is not care." He copied it onto a card and taped it inside a locker. The tape curled at the edges after a while. The words did not. Laura, locking her door on a clear evening, did not think about courtrooms or columns of elements. She thought about dinner and about a neighbor's child who had asked her advice on a school project about safety. She had told him to define the word before building a poster, because words collapse under decoration. He had returned a week later with a simple board that read, "Safety is what remains after truth and boundaries are applied." She had told him it was good work and meant it. If you stand on the Kesslers' porch now, you can hear what porches always hear. A car door, a bicycle chain, a distant dog. The concrete holds heat for a while and then gives it back. At 10:12, nothing special happens. That is the victory available in this kind of story. A moment returned to ordinary use. The case belongs to archives and to people who study how rules work. The rest belongs to the living, who keep choosing sentences that are not performances and doors that close because someone thought to install hinges. Nothing dramatic announces the end. It is simply the place where the narrative no longer needs to hold itself tight because the structure around it finally does. Here, the story concludes. What remains is the work. To say the rule, to keep it when tired, to repair what can be repaired, and to accept the quiet mercies that arrive when no one is narrating. The porch is quiet. The door is locked on purpose. The house keeps its shape.